Welcome to the ACE Your RES Exam Case Studies Deep Dive. Today we're jumping straight into a deep dive, exploring some real-world case studies. These are specifically picked to help you navigate the complexities of being a real estate salesperson.
Yeah, and our mission is really to pull out those critical lessons from these examples.
Exactly. The kind that don't just help you ace the RES exam, but actually help you build a career that's, grounded in ethical, compliant, and professional practice. And hey, before we get started, seriously, take just 2 seconds right now, like this deep dive, subscribe to the channel.
To call.
It's honestly the best way to make sure you don't miss any future deep dives. Could be vital for your professional journey.
Absolutely. And the cases we're about to unpack, they aren't just theoretical scenarios.
Right.
These are real consequences that real professionals face because of, well, specific actions or sometimes just a critical lack of due diligence. Think of them as really practical illustrations of why the rules matter so much.
Okay, let's get into it. Case number 1 dives straight into something pretty foundational for every RES maintaining your professional standing. Specifically, this is about someone trying to find a shortcut around their continuing professional development, or CPD, requirements.
Ah, yes, CPD. It's non-negotiable, really. Mandatory for renewing your license or registration each year.
And it's 6 credits annually now, right? Since late 2019.
That's right, 6 credits. And the rules are very clear. It requires personal attendance. It's the industry's way, of making sure everyone stays sharp, updated, and competent.
So, okay, enter some Usen, also known as Caleb. It seems he thought there must be an easier way.
Precisely. According to the case details, back in August 2022, some reached out to another RES, Jason Go, someone he knew from a previous agency.
Right.
And some basically asked Go if he would attend some online CPD courses for him.
Wow. And Go actually went along with it.
He did. The plan was Go would attend 2 online Zoom courses worth 4 credits, so a big chunk under Sum's name.
So he just logged in as Sum.
Yeah. Go used Sum's login details, accessed Sum's email to get the course links, and attended the courses via Zoom, appearing on the video feeds and, using Sum's name.
And the course provider had no idea.
Company H, the provider, was completely unaware it was Go participating, not Sum.
Okay, so Go does the time, Sum gets his certificates, pays Go back, then Sum applies to renew his registration.
Exactly. In November 2022, Sum goes onto the ACS system, that's CEA's online portal, to renew his registration for 2023.
Knowing he didn't actually attend.
Knowing full well he hadn't personally attended those 4 credits, but the system, based on Company H submitting the attendance, incorrectly showed he had met the requirements.
And Sum just let it slide, didn't correct it.
Chose not to correct it.
Okay, but things unraveled. CEA got a complaint.
They did. CEA launched an investigation, and here's where it gets even worse. Sum actually made false statements during his interview with them.
Oof, that's digging a deeper hole.
Definitely. It just shows how quickly trying to bend a rule can, spiral into outright deception. And the consequences, they were pretty stark and different for each person.
Okay, what happened to Sum?
Sum was charged and convicted in court. This was under Section 64 of the Estate Agents Act 2010, essentially for intentionally suppressing a material fact. The fact being his ineligibility for renewal because he faked the CPD. The court fined him $6,000.
$6,000, okay. And Jason Go, the one who actually attended the courses.
Go faced a CEA disciplinary committee. His breach was under the Code of Ethics and Professional Client Care, the CEPCC, paragraph 7.1 read with 7.2a specifically.
Which it basically means?
It means he did an act that could bring discredit or disrepute to the industry by, dishonestly agreeing to attend for Sum, pretending to be him. His penalty was a financial one, but it was huge. $20,000.
Wait, $20,000? For Go? That's way more than Sum's court fine. Why so much?
It really underscores how seriously CEA views the act of dishonest misrepresentation and undermining the integrity of the professional standards system itself. It wasn't just about ticking a box. It was about active deception. Complicity carries a massive risk.
Right. The industry perspective you mentioned really drives this home. CPD isn't just some administrative hoop.
No, it's fundamental. High professionalism depends on it. Faking attendance isn't just like bending a rule. It's viewed almost like professional fraud. Completely unacceptable for an RES.
So the sharp insight here is crystal clear.
Yeah, it's simple but powerful. Don't just attend CPD. Be present. Engage with it. Trying to game the system isn't some clever shortcut. It's professional deception with potentially criminal penalties and definitely big fines for everyone involved.
Okay, that covers internal compliance, staying straight with the requirements.
Yeah.
Let's pivot now to client-facing compliance. Getting HDB rules absolutely right.
Yes.
Starting with the minimum occupation period, the MOP, and acquiring private property. This seems like an area where bad advice can really, really hurt your client.
Absolutely devastating consequences are possible. As an RES, you are genuinely expected to be an expert on HDB MOP rules, especially when it comes to clients wanting to buy private property. The regulator, HDB and CEA, take this incredibly seriously because it directly involves public housing policy.
And the numbers show this isn't a rare problem. You mentioned stats. From 2019 to 2023, HDB took action in 800 cases.
800 cases, yeah. For things like unauthorized rental or people not actually living in their flats during the MOP. And get this, around 70 of those flats were compulsorily acquired by HDB.
Wow. Compulsorily acquired. That's huge.
It is. And focusing just on RES, between January 2022 and October 2023, CEA took action against 20 agents specifically for MOP-related breaches. We're talking censures, financial penalties, suspensions. It's a frequent issue with serious professional fallout.
Those stats really paint a picture. They aren't just numbers. They're people's lives, their investments, their agents' careers impacted.
Exactly. And this particular case study involves an RES who gave, well, fundamentally wrong advice about MOP and buying private property.
Okay, so what was the specific bad advice given?
The RES incorrectly told their HDB flat owner client that they could actually acquire a private residential property during the MOP of their HDB flat.
How? What was the supposed loophole?
The suggestion was they could do it by holding the private property on trust for their minor child.
Holding it on trust for a minor. That immediately sounds like trying to find a way around the rules, doesn't it?
It certainly has that feel. And unfortunately, the client relied on this bad advice. They went ahead and acquired a private property while their HDB flat was still locked into its MOP.
Okay, so what happened when HDB inevitably found out?
For the client, the consequences were severe. HDB imposed a really substantial financial penalty, $45,000, just for infringing the MOP rules based on that advice.
$45,000. That's massive. And the RES, the one who gave the advice.
CEA took action against the RES too. They got hit with an $8,000 financial penalty and a 6-month suspension from practice, all for failing to conduct their business with due diligence and care.
So the agent's mistake cost the client tens of thousands and cost the agent their livelihood for half a year. What are the specific MOP rules here that the RES got so wrong? Let's clarify that.
Okay, the rules are actually quite explicit. They state that the flat owner, their spouse, and any authorized occupiers cannot acquire any private residential property, local or overseas, during the flat's MOP. That's the baseline.
Right.
But here's a crucial part that's often missed or misunderstood. If a single person buys the flat and then gets married during the MOP, then both the owner and the new spouse must fulfill the MOP together. That means neither of them can acquire private property during that remaining MOP period.
Even if the spouse wasn't on the original application when the flat was bought.
Correct. When you get married, your spouse is automatically considered an essential occupier. They become subject to the MOP rules regarding private property acquisition. Doesn't matter if HDB has been formally told about the marriage yet or not, it's in the terms and conditions, clause 29.5I and 28.5C. And, critically, as this case really highlights, trying to acquire private property to hold on trust for someone else, like a minor child, during the MOP, that is also strictly not allowed. It's not a loophole.
So that trust idea was precisely the faulty advice. The lesson here seems pretty clear. When it comes to MOP and buying private property, you cannot guess. You can't rely on these kind of trust arrangements or supposed loopholes, and definitely don't assume a spouse isn't bound by the rules.
Absolutely. Bad advice here is just incredibly costly for everyone.
So the sharp insight.
MOP advice rule #1, never guess, never advise based on a supposed loophole involving trusts or minors during the MOP. It's not worth it. The client paid $45K, the agent lost their license for 6 months. Just stick to the facts.
Right. Okay, let's move to our third and final case study for today. This one also deals with HDB MOP rules, but focuses specifically on facilitating rentals within the MOP period.
Yes, another really common area where things can go wrong. When you're helping clients rent out HDB properties, you have a fundamental duty to make sure they're complying with HDB's rules. And that includes the MOP, which, generally prohibits renting out the entire flat.
This case involves an RES named Eng Ni Ni. What was the core issue with what she did?
Well, she basically facilitated two separate tenancies for a client's HDB flat, even though she knew the flat was still within its MOP.
Okay, so she knew about the MOP.
She knew, and crucially, she knew the client wasn't allowed to rent out the whole flat during MOP. She also knew that the client couldn't just lock up one bedroom and rent out the rest of the rooms either. That's also not allowed during MOP if the owner isn't living there.
So she was fully aware that both ways the client wanted to do it were breaches of the rules.
It appears so, yes. Let's look at the first tenancy. Eng advertised the whole flat for rent. She even confirmed to a potential tenant it was for the whole unit. Then, during the viewing, she told them the owner was overseas and was just locking up belongings in one bedroom. But then, HDB officers inspected the flat in December 2020. They found the owner wasn't living there. The tenant, understandably, felt uncomfortable with the whole situation and ended the tenancy early.
Right, so she got caught, the tenancy fell apart. Surely that would be a major wake-up call.
You'd think so, but apparently not. Just 2 days after that HDB inspection?
2 days.
Yeah. Eng advertised the whole flat for rent again.
Unbelievable.
To a new prospective tenant, also in December 2020, she repeated the story owner's overseas, not staying there. During the key handover, she said again, owner won't be staying, just locked up one bedroom. But the second tenant also had to move out abruptly in late January 2021, probably after HDB followed up with the owner.
Facilitating a second illegal tenancy immediately after the first one blew up because of HDB scrutiny, that really shows a serious disregard for the rules.
It certainly does, and the consequences for RES Eng reflected that. She was convicted by a CEA disciplinary committee, among other things, for facilitating an HDB flat rental that breached MOP rules.
What was the penalty?
The disciplinary committee imposed a financial penalty of $4,000 and a 5-month suspension from practice, which started in April 2023.
Okay. Now, the industry perspective on this, from Thomas Tanzi Haofong, I thought that was quite insightful. It went beyond just this one agent's actions.
Yes, he made some really important points about regulatory adherence and ethical responsibility. He acknowledged, the pressure agents might feel from clients sometimes.
Right, the pressure to make the deal happen.
Exactly. But he stressed that prioritizing compliance with the law and the profession's ethical standards has to be paramount, even if a client is pushing hard for something illegal.
He also made a key point about why these rules exist, didn't he? The Housing and Development Act.
Yes, he highlighted that the act exists for good reasons, to ensure public housing is used appropriately and to maintain the integrity of the whole system. As agents, you have a clear duty to uphold these regulations and give accurate advice based on them, not find ways around them.
Which brings us to that really tough situation. What do you actually do when a client directly asks you to do something you know is illegal or unethical?
According to this perspective, and I think it's the right one, the agent must exercise professional judgment. You have to firmly refuse to participate in any activity that breaks the law. Doesn't matter how much the client pressures you or how much commission you might lose.
Which is clearly what RES Eng failed to do here. Twice.
Exactly. She chose to proceed even though she knew the MOP rules weren't being met and the client was asking for something improper. That jeopardizes the agent's own standing, damages client trust eventually, and ultimately undermines trust in the entire industry.
It's a stark reminder. Upholding integrity and legality always has to supersede just accommodating client demands when they cross that line.
Definitely.
The source also offered some practical tips, recommendations to help agents avoid these kinds of situations.
Yeah, these are excellent reminders for any RES. First, thoroughly educate your clients. Explain the rules, like MOP, very clearly, and explain the consequences if they break them.
Makes sense.
Second, document the advice you provide. Keep good records of what you told your clients, especially about legal stuff. It protects you and them.
Okay.
Third, seek legal counsel if needed. If you're ever unsure about a complex rule or situation, don't guess. Ask an expert, maybe consult your agency's legal team if they have one.
Right, don't wing it.
And fourth, crucially, refuse non-compliant transactions. You have to be firm. Say no to deals, violate the law, even with heavy client pressure. Your license and reputation are way more valuable.
That last point really nails the lesson from this Eng Ni Ni case, doesn't it? Compliance isn't optional.
It's non-negotiable. Upholding the law and ethics always comes before client demands if those demands are improper. Prioritizing integrity and legality isn't just good ethics, it's how you build a sustainable, trustworthy career.
It's the line in the sand.
Absolutely. Every professional has to be ready to draw it.
Okay, so let's pull back a bit from these specific stories. If we look at all three cases, What are the big overarching lessons we can take away from this deep dive?
Well, I think we've seen really clearly through these real-world examples just how absolutely necessary it is to comply with regulations, whether it's something personal like your CPD requirements or complex client-facing rules like HDB MOP and rental restrictions.
Yeah, compliance is key. And there's also that fundamental theme of personal integrity and honesty, right? Don't try to game the system, like with the CPD case.
Exactly. Don't make false statements. Don't suppress material facts. As we saw, the consequences can escalate really fast and become quite severe.
And professionally, the duty of diligence and care came up repeatedly.
It did. Your clients rely heavily on your advice being accurate. Getting crucial rules like HDB MOP wrong can have huge financial impacts on them, and as we saw, serious professional consequences for you, fines, suspensions.
And finally, that ethical obligation. Being prepared to refuse a transaction that violates the law, even when your client is pushing you.
Yes, your responsibility to the law, to the ethical code of conduct, it has to come first.
Because these cases vividly show the significant consequences when rules get broken, for everyone involved.
Big time. Fines and suspensions for agents. And for clients, massive financial penalties, or even, in the worst case, losing their property.
So when you frame it like that, these case studies aren't just, cautionary tales. They're incredibly valuable learning opportunities.
Absolutely.
If you're preparing for the RDS exam, they show you exactly why you need to learn these rules inside out. They're not just abstract concepts.
And for practicing RES, they're a crucial, practical reminder of your ongoing responsibilities and the very real impact your actions or your advice can have.
They really are lessons learned the hard way by others.
Offering a clear roadmap of pitfalls to avoid, hopefully helping you ensure a long and reputable career in this industry.
Well, this deep dive into these crucial case studies has definitely highlighted the serious side of professional practice in real estate.
Indeed, it has. Understanding these examples, these potential pitfalls, it's vital for anticipating challenges and just consistently adhering to those high standards that are expected of you as a real estate professional.
So, maybe here's a final thought for you, our listener, to chew on after hearing these cases. We know it's a competitive industry. Facilitating deals is key to your livelihood. Keeping clients happy is paramount. How do you really internalize the resolve, the strength you need to navigate that difficult moment when a client's request clearly crosses an ethical or legal line? What does professionalism truly demand from you in that specific, high-pressure moment of decision?
That's a really good question. Something definitely worth reflecting on for anyone building or continuing a career in this profession.
Thank you so much for joining us for this deep dive into these crucial case studies.
Yes, thank you. We hope this helps you on your learning journey and inspires you to always aim for the highest professional standards in everything you do.